Hi, this is Sean Hendrickson here at the Sean Hendrickson Law Firm, where we help good people like you avoid the devastating consequences of criminal charges. Today, we're going to be talking about what happens when a victim in an assault case or family violence case, what happens when they want the case dismissed. Before we get to that, I do have a free download for you, 4 things you should be doing right now if you've been arrested. You can look down in the notes. There's a link down there and click on that link and we will send that right out to you. And if you do have a case here in the San Antonio area, we've also got a link down there where you can schedule a free consultation. Feel free to click on that and we're happy to discuss your case with you. I talk to a lot of victims and cases because as part of my job, I've got to contact each witness to basically check in with them and to see what their side of the story is, so that we can prepare the best defense for our clients. In a lot of cases, when I'm talking to those victims, they want the case dismissed or they don't want to cooperate with the district attorney's office. They just don't want to go through everything. They just want everything to be behind them. And so a lot of times I'm talking to people who want the case dismissed. And there are a lot of reasons for that. They may not have wanted the person arrested initially, or maybe they changed their mind. Or maybe they just don't want to take the time off of work to go to trial and testify. The district attorney's office and the police are also going to be talking with the victim. And what they'll tell the victim, if the victim wants the case dismissed or doesn't want somebody arrested, is technically true. And that's that the state is the one who's bringing charges against a person, not the victim. What that means is that just because a victim wants a case dismissed or wants somebody not to be arrested, ultimately that's not going to be enough. So ultimately, for a case to get dismissed, that's up to the district attorney's office when somebody's already been arrested and charged. But what they're going to leave out is a huge factor, which is that if the victim does want the case dismissed, then there are things that victim can do that make it more likely to get dismissed. And while it's not the only thing that matters, it is a big factor, especially in assault cases and family violence cases. Family violence cases in particular can be hard for the police and for the district attorney's office. When the police show up, in most cases, it's just 2 different people, and the police are usually trying to figure out what's going on. And it's not always clear what happened. There may be injuries on both people. Both people may be saying that the other person started it. A lot of times it can be hard for the police to figure out exactly what happened. And quite frankly, a lot of times the police get it wrong. I'm not sure if, they're not trained well on this or if it's just, hard no matter how much training you go through. And the other thing is that a lot of times police will say that since the police get called out, somebody's going to jail. And then ultimately they just pick somebody. And sometimes when reviewing videos and police reports, it's hard to figure out why they arrested one person and not another person. Because of that, there's a lot of people who get arrested on family violence cases that never should have been arrested. Either they didn't do anything or they were acting in self-defense, or maybe they were both just fighting and, there's no telling who started what. When we compare family violence cases to DWI cases or drug possession cases, in a lot of these instances, there's not a lot of evidence. It's a he said, she said sort of a case. And in a lot of times, there's a lot of emotion and a lot of background. And so it's hard for anybody to figure out, who exactly is telling the truth in the case. And if the case is going to go to trial, then you need the victim to show up to testify in most cases. If this is the type of case where there were no witnesses and it was just the 2 people in the room, then for the DA's office to get a conviction on that case, they need the victim to come in to say what happened. If the victim does come in to testify and they're not credible and the jury doesn't believe them, then it's going to be even harder for the district attorney's office to get a conviction in that case. The prosecutor will call the police to testify also, but the officers can only testify to what they actually saw. If they got there and the parties had already separated, there's no fighting going on, which is in most cases, then the only thing that the officer can testify to is what they saw. So they could say that this person had an injury on them or that person had scratches on them, but they can't testify as to how that person got those injuries. And so if the victim isn't being cooperative with the district attorney's office, then that's a major hurdle in the DA's office getting a conviction on a case. There are ways around that for the DA's office. If the person who was arrested made any admissions, then that can be used against them. Or in 911 calls, sometimes those can be brought in. But in a lot of cases, without the complaining witness or the victim testifying, it's tough for the DA's office to win these cases. That all brings us back to, what if you're the victim in a case and you want the case dismissed? The first thing for you to decide is to decide what you want to have happen. So do you want the case dismissed, or do you want the person punished on this case? And if you do want the case dismissed, then there are certain things that you can do that make it more likely that this person's case is going to get dismissed. Remember, you have no obligation and no duty to talk to the district attorney's office or the defense attorney in this case. If you want the case dismissed, I recommend first calling the defense attorney on the case to see if there's anything that you can do in this particular case that's going to make it more likely that the case is going to get dismissed. The other thing is that the DA's office is trying to get a conviction on this case. And normally they're going to reach out to you. Sometimes they'll reach out to you quickly. Sometimes they'll take a while, but they're probably going to try and reach out to you a couple times during this case. And a lot of times, especially the first contact, is going to be somebody called a victim advocate. And they may not even tell you that they're from the district attorney's office. The way that I see most of these cases getting dismissed is if the district attorney's office isn't able to get in contact with you, because they're going to want to confirm the story. They're going to want to see if you're going to be able to come in, if this were to go to trial, to testify. And if they can't get in contact with you, or if you're not answering their questions or anything, then that makes it more likely that they're going to dismiss the case. Ultimately, it's your decision on who you talk to and who you cooperate with on this case. You've got no legal obligation to talk to either the district attorney's office or the defense attorney on the case. But who you talk to and who you cooperate with is going to be a big factor in what happens on the case. If you do want the case prosecuted, if you're cooperating with the district attorney's office and letting them know that you will show up to trial and testify, that's going to make it more likely that the case is not going to get dismissed. On the other hand, if you're cooperating with the defense attorney and you're not answering the phone calls of the district attorney's office or not talking to them when they do call, then that's going to make it more likely that the case does get dismissed. Ultimately, though, you don't have any obligation to do anything on the case until you're subpoenaed. If you are subpoenaed, that is a court order demanding that you go down and testify at the trial. However, even with a subpoena, you still don't have to talk to the defense attorney or the district attorney's office. The only thing you have to do is go down to the courthouse, and if you're called as a witness, you have to go up on the stand and testify. I hope all of this has been helpful for you. If you do have any questions about this, or if you or loved one are being charged with our case here in San Antonio, feel free to give me a call at 210-942-4997, or you can click that link down in the bottom to schedule a free consultation. I'd be happy to discuss your case with you, and I hope that you have a great day.